something. And then so that'll give us an extra class or so. And so I think we should probably just use that as a review. That sounds like a good plan. And so from now until then, I would, this weekend, next weekend, just go back over the notes and find out any gaps or anything. And so something that you said that doesn't sound clear to me, that'll be good. And then before the review, you just send me all the questions that I can look at. That'll help me sort of see where we need to emphasize things. Also, this week I'll post a old exam and I'll answer. It is a short answer and a little longer answer. But no surprises, it'll be on some of the problems that we discussed and how we discussed them in class. So you don't have to look at rule numbers. I don't expect you to know 3.3 or 4. I only put the rule numbers. I told some of you individuals just saying it to the class. I only put rule numbers up when your comments up on the board so that you look at them and help you understand the rule. And also get you in practice. I think when I practiced, I just kept the book on my desk. So I think you should actively look at the rules as you practice if you have any questions. Well, I didn't want to get the impression I just sort of do it. I would just talk to people, but it's good to sort of look at the rule and talk to people in practice as well. You'll probably have a managing law clerk if you're in a big firm, or your supervisor if you're in a smaller firm, or public interest. There's always somebody you can talk to, so that's important. So we have done most of the substantive work in the class, particularly with conflicts. But to me, this is just as important because this could be what we've been talking about the last class and this class. This could be a sort of conflict too. Because we emphasize that we have undivided loyalty to our client, but there are also outside interests. We talked about those at the beginning of class. We talked about our duties as officers of the court. Our duties not only to comply with these rules, but other law. So if you're in front of an administrative agency, of course you have the rules of professional responsibility, but you have those rules as well. Or if you're practicing in the Western District of Kentucky, you have these rules as well as the federal rules of civil procedure, evidence, and the local rules of the court. Also make sure you check that. And then below local rules of the court, the judge that you are appearing before may have internal rules of his chambers as well, her chambers. So all that's important. Anyway, we have been talking about lawyers' duties to third parties. And we get a problem. We get on page 541, emergency food stamps. And the whole purpose of that was to talk about truthfulness and statements to others. So that was on page 541. And we had a number of different options. And the themes that ran through that problem was, is there an obligation to tell the absolute truth? Are we choosing between truth or justice? Is this type of communication where you call an office and say that the district manager is on the phone, even though that's a lie, just to get someone to the phone and then identify yourself? Is that similar to a negotiation where you may slant the facts a little bit? There was a pressing interest in that problem. The client might go hungry. The office itself that we contacted probably was lying too because they said, oh, we can't find the supervisor. And then when we call back and say that the district manager is on the line, someone immediately comes to the phone. So there's sort of lies going back and forth. And can lawyers unilaterally define what justice is? Is that important? Harm to future clients. So we ultimately came to the conclusion that under 4.1a, this isn't really a material fact. Truthfulness in statements about the course of representing a client or lawyer shall not knowingly make a false statement of material fact. And we were discussing this, and another of you made the point that not really a material fact because whether or not she gets the food stamps or not, that really doesn't change. You're not altering anything. You get the person to come to the phone and then identify yourself. Even though the person on the other end of the phone was slightly annoyed, we caught that person in sort of a misrepresentation and allowed us to get emergency food aid, which was perfectly fine under the regulations to our client. So we talked about that. Then we made some comparisons. You see on page 543, that lawyer was publicly censored because this is a true example of an attorney assisting client in fraud, holding a valueless check in order to close a transaction. So that's assisting fraud. Then we looked at other cases to make a number of points about whether or not this is dishonest conduct. Looked at testing cases. And there's some propositions set out on page 547 that talk about whether or not you are endorsing dissemblance. And no disciplinary case really addresses this issue, but it seems like if you're talking about a substantive constitutional right or some type of civil right, there's a good faith basis to investigate, that's not really a line, that is investigate. We looked at that. We looked at the notion that context matters in negotiations. And then finally, we looked at the messing case on page 558. That case made the point, looking at rule 4.2, communication with a person represented by counsel. We know that we cannot communicate about the subject of the representation with a person that we know to be represented by another lawyer. Now, that knowledge has to be actual knowledge of the fact of representation. And notice it talks about the subject of representation. You can talk to that person about anything else, just not the subject of representation, because the person is represented by counsel, and we don't want anything outside of that representational relationship to interfere with the advice that the attorney and client are sharing back and forth. So, and this rule applies even though if you have a scenario where the represented person initiates the conversation. So you can't say, oh, I know that you're represented, but you can't initiate, so therefore, if you know that the person is represented by counsel, you shall not communicate with that person. Unless the lawyer has the consent of the other lawyer, of course. So we did that. And messing was an example that you recall. That was a case where a security officer at Harvard sued Harvard for gender discrimination. And Harvard sued back under 4.2 on page 559 in saying that the law firm had violated that ethical rule by contacting people who were represented by Harvard without notifying Harvard's counsel. But the court made some fine distinctions in that case. The court banned contact only with those employees who have binding managerial authority. So even the interviews of this security guard's two supervisors, that was permissible because they didn't have binding managerial authority. In other words, their conduct could not bind Harvard legally for any type of liability. Then we talked about dealing with unrepresented persons in terms of that chart on page 561. And so I want to jump over to this first problem, problem 12.2, the breaking. That's going to be interesting. So this is kind of a... It's on page 562. Okay, breaking. So we have a battle for joint custody between Cheryl Gardner, who we represent, and her ex-husband, Ron. They have joint custody of their daughters, 5 and 7, and Cheryl is seeking to obtain sole custody. Cheryl believes that Ron has been molesting his daughters, and Ron may even be planning to kidnap his daughters and take them to Kuwait, so she'll be totally isolated from her daughter. We know that Ron has obtained passports for the children, Neither girl says that her father has molested her, and the court's sex abuse program, the county sex abuse program, has examined the girls and found no evidence of abuse. Ron's lawyer has been arguing vigorously for joint custody. So one day, our client bursts into the office, and she has documentary evidence of sexual molestation of the girl. Apparently, she broke into Ron's house, went through an open window, took all of these documents, Xeroxed them, put the documents back, and now we have her giving us these documents. Documents substantiate that there's photographs, there's a diary, and a novel that all substantiate what Cheryl believed was occurring all the time. So essentially, our client stole these documents from Ron's house. It asked us to look at a number of different rules. Asked us to look at all of these rules to figure out what should we do. So, got 1.1, got 1.2D, got 3.3, 3.4A, 4.4, 8.4. Assume that the state's child abuse reporting statute does not apply to lawyers. So that's sort of to drive this problem a little bit. And we have all these rules to look at. And we also had the discussion about what to do when we are holding on to our client's evidence. So how would you approach this happened to you? How do you put up everything? So all of these things are impacting our conduct. That the lawyer knows. So one thing we're thinking about is our client broke the law, and how close are we to that? So one thing, can we say we weren't involved in this fell into our lap, and so we're good. That's one approach. April for just general misconduct. Cannot engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And then 4.4 talks about what we talked about in the last class. Lawyer receives a document, just paraphrase, reasonably should know that the document, now this is the problem, can't on some level say inadvertently, we know it was stolen, but we didn't actively encourage that. So do we have a duty to notify Ron and his attorney? I mean, this is a little bit more than something being faxed or scanned to your office and you know that it's the opposing counsel's document and you return. So what are you doing in this case? Our client has actively broken the law, we know that. And of course, the third person on the other side, Ron, is certainly not sympathetic to us or society or whatever, but we have these stolen documents. How should we use them? Can we use them? What should we do? You know, one thing that could get you in trouble too is, are these documents really stolen? I mean, we put them back. We Xeroxed them, so he still has the original documents. So that we still, it's hard.
That's kind of what's confusing me a little bit. Is because at least with Freedom of Right, like we're technically not in the technical system, we're not obstructing the right because they actually still have the documents. The documents themselves are not removed; they were Xeroxed in the copy. Right. So they still have access to it. So but at the same time, it's still stolen information. It's just the originals weren't stolen.
Yeah.
It's a weird situation, and then it's like we did not have a plan to break into somebody's house and steal this evidence.
Right.
They did that on their own.
Right.
So I guess first thing I would say is her name is Cheryl, right?
Yeah.
I'd be like, what the hell, Cheryl? I'm sorry. When did I say you could break this?
That's great. So after that, so I'm just say, what the hell, Cheryl? You still have these documents, what?
I mean,
you're stuck. I know it's funny, but we're stuck with this client.
It's like, first off, even though this, like, if you had gotten this, like, legally, yeah.
You're gonna be surprised what happened in real life, because some of these things with the rules, we know what the rules are, but human nature comes into play, and all of these complexities. You'll see, really? But go ahead.
I mean, and it's.
We have to work our way through this problem based upon the rule. So we say, what the hell, Cheryl? What do we do?
I'm sorry. I'm a little.
One thing we do, what about this? Destroy these documents. This is bad news. You should have done this. At least the originals. Destroy them and never refer to them again. Like it never happened.
That's not an option either. It's just like that.
Why not? You said the documents are still there. We can just nobody know.
But then it's like a situation with church where even you may destroy it, but you still have to acknowledge that something has occurred.
Yeah.
You still know that a law has violated. You still know that this has happened.
Yeah.
And if it comes out and if it's going to come out and watch it, like if they somehow find out that your client broke in and and mess with these documents,
Yeah.
then that's going to come back to haunt you. So just destroy it and never refer to it again. Just avoiding it is not the answer
Okay,
either.
that's good. Okay, Ms. Cruz, go ahead. Yeah.
I would not destroy the documents.
Okay.
I wouldn't want to take the risk that he, on his private time, is going to destroy the documents. I mean, it only takes a matter of seconds to make a decision like that. I'm sure she's not the smartest client, but clearly, no one believed her, and I would argue harmless error. She had to take the law in her own hands because he didn't have anyone on her side.
Yeah, harmless error. But then, so let's say we tell the court this, everything we weren't involved. No one believed her. This was the only way to substantiate. The court could look at you and maybe discipline you, even though you say you weren't involved. And also, the court could say, since this evidence is illegally obtained, I'm not going to let you use any of it. That's the problem too. But you make a good point. Maybe the client is willing to risk being sued or prosecuted, and the lawyer should just move forward. If the client is willing to accept that personal risk, maybe show these documents to opposing counsel and urge him to press his client to abandon the custody claim. So my client says, okay, this is the only way we can prove it. I know I might get prosecuted or something could happen because I did. So what? This is how we do it, and then you use the documents. Is that okay? Ms. Moore?
Given the severity of what she found,
Yeah.
being that we're only mandated reporters or documents, wouldn't
Well, look. The state's abuse reporting statute does not apply to lawyers.
about that?
Okay. Yeah, that parenthetical. Assume that the state's child abuse reporting statute does not apply to lawyers. So that makes the problem a little bit more difficult. Yeah. So, but still, go ahead. Teresa, what were you going to say?
I was just gonna ask if we were mandated reporters, that would be our confidentiality.
Yeah, it probably would because it would be under 1.6 to comply with other law, and that would be a substantive reporting statute. And so I think the answer to that would be yes, but that's why you put that little parenthetical in the fact, so to drive the problem a little bit more. Tell the opposing counsel that you know about the criminal conduct and show the documents. What about that? So, go ahead. Go ahead.
3.3b, where it talks about taking, when you know there's criminal or fraudulent conduct, to take reasonable remedial measures. It seems like that scenario you just gave about the counsel qualifies as a reasonable remedial measure, like confront the other side and say, look, these are stolen, but we have the information.
Yeah, I'm still, so what do you think would happen? So reasonable remedial measure would be saying this was stolen. So yeah, so reasonable remedial measure, usually talking like to the court or someone who can provide a remedy. What would we be remedying when we talk to opposing counsel like that?
Yeah, it's not perfect. That's the role for tribunal.
Yeah.
I mean, there might be some strategy in that too. You just tell the tribunal, hey, these are stolen, but we have them. They seem, even if it's not admissible, we can still have something.
But then the court says, okay, you perform your duty. That's great, but the way that these were obtained, I'm not comfortable with, so I'm going to suppress. Then what? What do you think? Yeah. Then we have misconduct. We have all these things that could impact us. So notice, you pointed this out, none of these rules are a perfect fit. We didn't counsel our client to do this. The client just did it. We're not unlawfully obstructing because the evidence is still there, even though it was stolen. Receiving this document isn't really inadvertent. So do we really promptly notify Ron and his attorney? And then what are we trying to remedy if we say to opposing counsel what is going to happen? So what do you think happened in the real case? And it's just, you really respect on that. Go ahead.
I think that in a real case, the lawyer probably tried to use something to the other side to do what they wanted.
Yeah, that's good.
That's
That's what happened, and nothing else happened. Nothing else happened. So that's good. So in the real case, the attorney showed the ex-husband's attorney some of the documents that the client had obtained. And the attorney explains that, yeah, we know that your client is a child molester, and here's proof. And the ex-husband's lawyer, Ron's lawyer, was completely unaware of this and was totally surprised, and didn't ask where it came from. So on the morning of the trial, the trial was to begin, the father agreed to give sole custody to the mother. And that was that. The lawyer was so shocked that he never asked where those documents came from. So and that's an example, I guess, of the rules not totally fitting in real life and whether or not to take that risk. This attorney did. Somebody said this is so serious and heinous that the attorney almost has to do this. This is what the attorney did, and the result was good. Now at trial, there could have been a scenario where the court may have excluded this evidence because it was unlawfully obtained, but that's not what happened. It's not what happened. Now let's talk a little bit about duties of prosecutor. Now if you look at rule 3.8, so we'll take us through these rules. This is still in line with what we're doing. This is special responsibility of a prosecutor, but the prosecutor duty is not only to the state as a client, but also to third parties. And so that's what we're dealing with here. So you look at rule 3.8. Special responsibility of the prosecutor. I'll just put this. Minister of Justice. So how does 3.8 work? And we're setting up this case, the prosecutor's masquerade. There are a lot of different rules that will impact on conduct. When we look at 12.2. I'm sorry, 12.3, the prosecutor's masquerade on page 573. But before that, what? Run through 3.8. So what does this rule say about how prosecutors should conduct themselves under the rules of professional responsibility. And this is totally different than what you see on TV, so what about this? Yeah?
They shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause, so no bringing frivolous charges against someone.
Yeah, and so notice that sounds like something that's written in stone, but the readings and real life tell you that probable cause isn't that hard to establish. You know, there's always saying a prosecutor can indict a ham sandwich. That's the little cute phrase, but it just says that the level of proof isn't that high. Probable cause is certainly not beyond a reasonable doubt, and it's almost asking this lower level standard if it's reasonable to charge this person, then the prosecutor to do it. Almost charge first and then do the evidentiary investigation later to find if this charge is substantiated. So that's the first one. What about 3.8b? That almost codifies Miranda warnings, it looks like, and places the duty on the prosecutor to make sure that the defendant is fully informed, the accused is fully informed about the right to and procedure for obtaining counsel, and given a reasonable opportunity to do so. So don't bring charges without supporting them by probable cause. Make sure that the accused is aware of procedural and constitutional rights that we're seeing. Not seek to obtain from unrepresented accused a waiver of important rights, such as the right to a preliminary hearing. Now that's going to be important. That's what we're going to really be looking at. I'll just put not seek to obtain from an unrepresented accused a waiver. Right. So this is going to become important when we look at the next problem. So you see within this rule, even the first couple sections that we looked at, it's not that the prosecutor should be in the business of racking up wins and this is how many convictions I have. The rule codifies a broader public obligation to make sure that justice is properly administered. And certainly that means convicting people who deserve it proportionately in terms of what they've done. But there are procedural steps that a prosecutor must fulfill, and that's why it's special responsibility of a prosecutor. Not only representing the state with this broader notion of justice, and ensuring also that constitutional guarantees are not undermined. Letter D sort of codifies Brady, Brady material, exculpatory material. So this will become important when we look at some of the note cases following this. If a prosecutor knows that there's exculpatory evidence, has to turn it over. And that's the rule, and you've seen countless times where prosecutors haven't done that. Political motivations, win at all costs, all of that. But this 3.8 says, make timely disclosure to the defense of all information or information known to the prosecutor that tends to negate guilt of the accused or mitigates the offense. So that talks about sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor. So this is an affirmative duty that, again, the prosecutor has to seek justice. I won't go through all these, but letter G is important. Letter G and letter H of 3.8. What about 3.8G? What does that tell us the prosecutor has to do? Again, why don't these work structurally? It's people have been in jail like for 20 or 30 years and somebody knows that that person was wrongfully committed, maybe convicted, maybe even in the government itself, and no one ever says anything. And that would seem to be a violation of 3.H. But what about 3.8G and H? So you're a prosecutor, and the case is moving along. You're definitely winning. And then one day you come into the office and there's an envelope on your desk, and that envelope contains new information that actually exonerates the defendant. And you just secured a conviction. What do you do? Yeah.
Well, at that point, you actually have a duty to try to remedy the wrongful conviction or go back and let somebody know what's going on.
Right.
It's like an affirmative duty, not just like a order.
Yeah. So why do you think this is philosophical? Why do you think it doesn't seem like this rule works too well? Because it seems like oftentimes someone knows, but no one says anything. Or when they do know, they keep fighting. No, that's not what happened. We're going to fight this. We can appeal, but we interpret the evidence, and that's closed unless the court orders us to open it up. What do you think about that?
I think a lot of times attorneys maybe want to get more focused on getting a win than maybe what the right thing to do is. I think that can play into that sometimes. And some people maybe it's trying to convince yourself that it's not as serious new evidence as what it actually is. Maybe.
Right. And you would also get into saying, well, okay, maybe this time, maybe this evidence is shaky, but we know that this person's been involved in this type of behavior before. You know, going back to evidence, that's why we have the prohibition against propensity evidence, saying a person is this type of person, they've done it before, they're doing it again. And so you can convince yourself, well, maybe the evidence is imperfect this time, but we finally got this person who's been engaged in this conduct all along. So 3.8G says, when a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor has to remedy this in light of the new, credible evidence. Disclose that evidence to appropriate court, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant. And undertake further investigation, make reasonable efforts to determine whether the defendant was convicted of an offense that the defendant did not commit. So this new credible evidence prompts an investigation on behalf of the prosecution. Or, letter G is sort of not new and credible evidence, but later on, you know, clear and convincing evidence establishing that the defendant was convicted of an offense that the defendant did not commit. The prosecutor shall seek to remedy the conviction. Doesn't spell out what the prosecutor has to do, but says you must try to remedy that conviction. Now, having said that, we have this problem on page 573. The prosecutor's masquerade. So bad case, horrible murder scene, and we have a DA going there, and we have Ward Flood, who is an abductor, murderer, rapist. And he even says on top page 574 that he's going to kill more people and not surrender until he gets legal representation. And so he wants a particular public defender, Harrison Biaggi, on the top page 574 to be his lawyer. Can't locate him. We call the number as the DA, and we just received a recording stating that the number is no longer in service. So the DA has a plan. Get on the telephone and we tell Flood, the defendant, accused, that we are an assistant public defender. We then negotiate with the police and arrange for his peaceful surrender in exchange for promises he wants isolation from other prisoners when they catch him and some cigarettes. You'll see to it that he in fact receives those minor benefits after he surrenders. So the question is, can we do this? Can we pretend to be a public defender, negotiate on Flood's behalf, and save the day? Because we're going to perhaps save more harm to the public. He even threatens to kill more people unless he gets the cigarettes, isolation, and the attorney that he wants. And so are we allowed to do that? Are we allowed to come in and represent him, in quotation marks, negotiate for him, and save the public from harm? Should we do this? If so, should you simply negotiate the terms of the surrender, or should you try to get information during your conversation with Flood that would assist in obtaining his conviction? So notice how this is set up. It sort of gives you two avenues. You can approach it procedurally, just negotiate, don't get any information that would incriminate him, and save the day that way, or you can go even further. Negotiate for him, get him to incriminate himself, because you are, quote, his lawyer, and he'll share those confidence with you, and then we can turn around and use that against him. What about this actually happened? So what? Is there, maybe there's an emergency exception. We're saving lives, so this is appropriate. What about this? So, we have a lot of rules that we can look at. We can look at 3.8, of course. We can look at 4.1, statement of truthfulness to others. Might have some misconduct. And we also have our old notion of confidences. But is there an exception? So what about that? Oh, we also have this too. So what do we do? So is are you confident saying that this is sort of he's a threat to society? He's already killed 3 people. He says he's going to do it again. This is the only way to get around that. So we negotiate, and that's fine. So think what you're doing. You are impersonating a public defender in order to resolve this situation. And so you're dealing, of course, with this isn't a sympathetic person, of course, but you're dealing with an unrepresented person. You're making misstatements to others because you're saying, I'm your attorney. You have your special responsibilities as a prosecutor. And you also have the catch-all that you cannot engage in conduct involving dishonesty, deceit, or misrepresentation. And also, you see on page 575, that whole discussion is saying that prosecutors are rarely disciplined. So that could explain some of the outrageous conduct we may see. So long, the text talks about so long as evidence supports a criminal charge, most people say that's okay. So what do we do in this case? What do you think? Yeah, go ahead, Mr.
I think I would lean towards just actually getting him a public defender, because you already have the 3-hour phone call where he confesses to everything that's been recorded. So, I mean, I think you probably have enough evidence. You have an eyewitness too, so I don't think you need to try to impersonate a public defender to try to get more information.
Okay, that's good. But time is, let me put time pressure on. Time is ticking, and we want to negotiate this to a resolution because he said he might kill more people. So apart from us having incriminating evidence on that phone call or whatever, can we be involved in sort of negotiating the resolution of this situation as his, quote, public defender?
I guess if you don't have time to get an actual public defender,
yeah, we don't have time.
I would say, I think I would leave that more for the police, to do rather
than gotta say these people.
Than as a prosecutor getting involved in that.
Yeah, I know you're very hesitant to be deceitful and dishonest in order to resolve the situation. If there's some other people who get involved, that's fine. But time is really ticking, and so what if you can't resolve it by just waiting on someone else? What do you think? Taylor? Yeah, go ahead.
My question is, technically arrested here, so I
Uh-huh.
don't, like, anything right, like, not about anything. But I think we technically use it, and then when they do it, then it's like, well, not, a lot of do it, but up to this point, I think, like, they're getting attention.
What about the Fifth Amendment, though? Incrimination. I don't think it's like that doesn't attach until you're arrested, right? I know what you're doing. That's interesting. You're saying the critical stages. Nothing is attached yet because he hasn't been apprehended. No custodial interrogation. All that's true. But then I guess the other question is, do you give up any constitutional rights simply because custodial arrest is not attached. I don't know. What would you do, Mr. Taylor? Though? What would you do?
I mean,
Would you like impersonate the public defender, then negotiate, save the day, and that's good?
I don't know if I would pretend to be a public defender. I would just see the same way of like, just like reason with them and kind of forget about that. Or,
Mhm.
yeah, see the same way or out.
Mm-hmm. Anyway, what do you? I'm gonna drag this out. I'm not gonna tell you what happened in real life yet, but interesting. Go ahead, Ms. Thompson.
I'm kind of a bit honest. I would not lie about who I was. I would like say, you know, I'm a prosecutor, but I would try to use that position to make and say like, you know, now I can we can discuss about making charges less, like, you know, mitigating circumstances, like try and say things that would at least entice him to come out. Because
Yeah.
as he's already pointed out, like he's technically not in, so everything has to be in the moment. So, and you're not trying to make him say things that would like everything. So you're saying like we can discuss like less of the charges, but we can't do that if you, unless you surrender and come out.
Yeah, sure.
I think perhaps like if you're already talking to him, the police could like track his phone number or something. That's not your job.
You could what, say what?
Like I mean, if you're talking to him on the phone, perhaps the police should do their job better at doing it.
Oh, yeah.
And it's like, oh, he's a police officer, you're a prosecutor.
Yeah. Well, what about resolving? See, everyone. What about that's good. What about resolving this situation though? He said the only way I'm going to resolve this is if you give me some cigarettes, isolation, and the attorney I want. And so, okay, I'm the attorney that you want, and I'm going to help you negotiate. And you say that that's the police job; they should negotiate or whatever. You just stay out of it.
Okay.
Yeah.
It's the police's job, it's not your job.
Yeah. So what should you do?
Me?
Yeah, as the attorney in this type of.
I wouldn't do anything.
You would, but then more people could get killed.
But you're like taking away his constitutional rights, and I mean,
What about, okay, I'll take away any of his constitutional rights, I just negotiate a settlement. I know this is the problem. I'm dealing with an unrepresented person, but in order to make sure that we remove this threat from the public, I take a sort of loose view of 1.6 in confidences. This is probably an exception, I would argue, and that I can do this. I'm not undermining his constitutional rights, I'm just resolving the situation. And so I don't even get anything that's incriminating or undermine any constitutional rights or anything because that's my constitution, but I resolve the situation. What about that? And some of you are saying, well, under 3.8, I am a lawyer and I'm seeking to obtain from an unrepresented accuser a waiver of important rights that he may not even know about because he hasn't talked to an attorney. And I'm saying maybe you can balance that and negotiate that by just doing something procedural in the negotiation. Okay, you have everything you want, will you come out now? That's fine. No harm, no foul. What do you think? And you've done some things in order to make this work. You are impersonating someone else to get all the information that you need and negotiating. And I guess if the confidences argument came up, you could sort of say, well, that is true about confidences, but there are exceptions under confidences, and maybe this falls under 1.6b1 to prevent reasonably certain death or substantial bodily harm. But we don't know, that's speculative, because reasonably certain death isn't that certain, because he just says, I'm going to do this if I don't get the counsel I want. And substantial bodily harm, that's speculative as well. So if we impersonate this public defender also, we could be in a situation of violating some constitutional rights. We have 3.8, prosecutor must not seek from a lawyer who has no lawyer a waiver of important constitutional rights. We have made false statements. That's bad under just 4.1, truthfulness to others, and the general prohibition against deceit and misrepresentation. And then 4.3, we're dealing with an unrepresented person. And we're on some level giving advice to an unrepresented person whose interests are adverse to ours. And that person doesn't even know that our interests are adverse because he believes that we are, quote, represented. So what do you think happened in this case? Any discipline? This attorney pretended to be a public defender, negotiated, saved the day, no lives are lost, they apprehend the criminal and everything's good. And the public in this jurisdiction applauded him as a hero. But what do you think happened under the rules? No disbarment or anything, but discipline, nonetheless.
Maybe censure.
No censure. Be worse than that.
Suspension?
Yeah. Only 3 months suspension, and that was sort of stayed for 12 months so he could still work. But found to have violated 4.3 and 8.4. So that's an example of that broad catch-all. So kind of a severe penalty. Look what he had to do. So during the time that the suspension was stayed, he had to retake the NPRE. He had to take 20 hours of continuing legal education on ethics. Had to have a supervisor with him at all times when he spoke to unrepresented persons. Had to pay the cost of the disciplinary proceeding against him. He appealed all the way to the Colorado Supreme Court, and the Colorado Supreme Court affirmed. But there was broad public support for the attorney's actions. The attorney wasn't fired or anything. He continued to serve as the senior chief deputy DA in the 1st Judicial District of Colorado. And he said throughout everything, he acted within the spirit of the rules of professional conduct. So that's sort of kind of a disconnect. Sort of did the right thing, saved the day, but violated the rules and was punished. There's an example on page 575, and this is an example of excessive prosecutorial zeal. And you have a prosecutor later admitting that perhaps, well, he did go too far. In fact, the person that he sent to jail was exonerated decades later. And it makes the point about prosecutors winning at all costs. I want to go over the Duke lacrosse case. What about that? So this is a rare case where both the prosecutor's discipline, Knife was disbarred for this. And so most people argue that a lot of this occurred because he was facing an election primary, so he just went overboard and prosecuted the members of the Duke lacrosse team. So a lot of things happening here: gender, race, privilege, all these things coming together. And then he withholds information, lies to the court. So he had exculpatory material that didn't fit the narrative that the prosecution's office was trying to advance. And he kept advancing it even though he had this exculpatory evidence. He eventually releases it, but tries to bury it in 1,800 pages of lab data. Took the defense lawyers another month to find the exonerating evidence. So notice on all levels, his conduct fails. He obstructs access to evidence, engages in rampant misconduct, undermines special responsibilities of the prosecutor, and violates several components of 3.8. If you look at 3.8, he violates 3.8D because he didn't give over exculpatory materials. He violates 3.8G. It's new credible evidence, but he held on it to it so long that it's exculpatory evidence that he knows. He doesn't remedy anything. And the evidence is more than clear and convincing, establishing the defendant was not guilty of a crime. And so you had a community in turmoil because of this prosecutor's actions in order to get reelected. And I think this bar probably permanently this bar. So I want to jump over. Look at page 585. Conduct prejudicial to the administration of justice. Now, this is in the book because it wants to illustrate that 8.4 is generally a catch-all, but these are instances where 8.4 has actually been used to discipline attorneys. So these general terms like deceit, misrepresentation, here we're talking about conduct prejudicial to the administration of justice. So look at the top of page 586. What is the common theme that you see running through 8.4D, which is what we're looking at? Engaging conduct that is prejudicial to the administration of justice. What type of conduct is this that the attorney is engaging in that undermines the administration of justice? For example, look at number 1 up here. This is a 1-year suspension, 6-month stay. You have an attorney calling a former client, advising him to clean up his act. She heard that a police raid was likely to be conducted in Worcester, Ohio, so she calls her former client and says, clean up your act. How's that obstruction of justice? Why is an attorney disciplined for that? So I guess this client gets caught, agrees to work with the police, testifies against the lawyer, and the lawyer gets disciplined. How's that? Is it obstruction of justice and something that is considered misconduct because you gave the client a heads up about what is going to happen? Or got in the way of the investigation? Yeah, what about that? What makes this obstruction of justice? And I'm not de-emphasizing this conduct. I just want to know what about it jumps out at you that it is punishable as misconduct. Just write it down. What do you think this?
I think she's violating 1.2D because she's assisting the clients possibly in conduct that is criminal by and going around the safeguards of the investigation of the drug raid.
Oh, so you're saying insulating criminal conduct by saying clean up your act if you're doing something, just evade the police, so that is assisting the client as well as obstructing the police's access to any evidence?
I mean, she would be under 8.4 obstructing. I mean, being involved in criminal conduct, keeping the police from seeing stuff they normally see.
Yeah, and throwing the police off course. So another form of misconduct, look at the 5th bullet point. You know, so law professors and deans are admitted to practice as well. They may not be practicing, but notice what happened. And this is sort of interesting. So U.S. News and World Report, everyone brings their hands about that and is calibrated on specific information. You know, how many volumes do you have in your library, scholarly publications, employment rates, LSAT score, GPA, all of those things. And so it's been controversial that a small number of law schools have used this information in an inappropriate way. And here we have a 3-year suspension for the dean of Villanova Law School for submitting inflated LSAT scores and grade point averages. Of entering law students to the ABA. So notice, this is fraudulent information going to one of the major institutions, the ABA, that accredits law schools from a lawyer, dean, and he gets a 3-year suspension for that dishonest conduct. That's another example of broad application of 8.4 misconduct. And then President Clinton, we saw that hypothetical, the judge's law professor, that is the hypothetical that sort of led to President Clinton being disbarred. Because notice his attorney, after finding out that President Clinton lied during the deposition, had to disclose that to the federal judge. So not only gave evasive and misleading answers, that comes from his own attorney saying, look, you did this, we need to correct this. And so that resulted in a 5-year suspension. Since been reinstated, I think. So we're going to stop there. That's the end of chapter 12. We're going to do chapter 13 in the next class, which is short. And then maybe one more class for the evolving business of law practice. That's just a major discussion. And then we will probably set up a review session before the final. And I'll post a exam and model answer by the end of this week. Have a good afternoon.